Okay, thank you everyone for joining. Welcome to the first call of the year for the International Criminal Law Committee of the International Section. Thank you for joining our call today. We are pleased to have a guest speaker today, and I will allow Alex to introduce our speaker.
Thank you. Sorry for the technical glitches. I had a lot of trouble getting into Zoom, and I apologize for that. If you can hear me, I hope you can. I'd like to introduce my long-term friend, Erwin Chemerinsky, is the Dean of the University of California School of Law at Berkeley, former Dean of the University of California School of Law in Irvine, I think graduate of Harvard Law School, Northwestern University, perhaps most importantly, the University of Chicago Laboratory High School, where we both graduated many years ago. Erwin being a distinguished graduate of that high school and my being a very mediocre one. But he's been very nice to maintain our friendship over the years. Erwin's published more articles and books than I can possibly mention, but his most recent one called Presumed Guilty, about the Supreme Court and its impact on police conduct cases and police abuse cases, has just been published to glowing reviews, including those including one in the New York Times book review. I can make another plug for Erwin, which is he has a wonderful podcast, or really a webinar every year. The annual Supreme Court Review on Practicing Law Institute is a great way to get CLE credits and a great way to hear about updates on the Supreme Court and its decisions in the recent term. They have a terrific panel like Judge Jed Rakoff and others that Erwin hosts, but also he's a very fine fellow, and thank you very much for joining us. So I'd like to turn it over to Erwin.
Thank you for that incredibly kind and generous introduction. I do very much cherish our friendship, which now is for over 50 years. What I was asked to do is talk about the coming term of the Supreme Court. I want to offer some general comments, then focus on most high-profile cases. Alex yesterday sent me a list of cases that he thought would be of special interest. I promised to cover all of them. The court will resume oral arguments next Monday, the first Monday in October 4th. I think that this term of the court is going to be a conservative movement for over 50 years coming to fruition. When Richard Nixon ran for president in 1968, it was very much against the Warren Court and its liberal decisions. He said he was going to appoint justices who were strict constructionists, who were committed to law and order. Ronald Reagan had an openly declared goal of moving the federal courts far to the right. Donald Trump, when he ran for president, said he was going to appoint justices who were committed to overruling Roe versus Wade. And he had the chance to appoint 3 members of the Supreme Court. By my count, and I think conservatives and liberals would agree with this assessment, there are 5 staunch conservative justices: Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. 1 moderate conservative in Roberts, to be sure right of center, but not as conservative as the other 5. 2 justices I regard as moderate liberals, Breyer and Kagan, and only 1 staunch liberal, Sotomayor. There were 2 until Justice Ginsburg passed away. So I think of this as a court that has a 5-1-2-1 split. How did we get here? After all, between 1992 and 2020, the Democratic candidate for president won the popular vote in every presidential election except for 2004. In part, we got here because of the Electoral College. In part, we got here because of the accident of history. Between 1960 and 2020, there were 32 years with Republican presidents and 28 years with Democratic presidents. Almost even. In fact, in 2024, it'll be exactly 32 years and 32 years. But between 1960 and 2020, Republican presidents picked 15 justices for the Supreme Court, and Democratic presidents picked only 8. Part of that, of course, was the Republicans blocking the confirmation of Merrick Garland, the Republicans rushing through the confirmation of Amy Coney Barrett. This is the first term where there will be the 5 staunch conservatives together for the entire year. And I think it's going to be, by any measure, a blockbuster term. As I alluded to, Alex sent me some possible cases to discuss. And I decided I'll cover all of those, but let me go alphabetically through what I regard as the most high-profile cases. At this moment in time, the court set about half the docket for the coming term. Yesterday, they had their long conference to the petitions that accumulated over the summer. If they follow the pattern of the last couple of years, on Friday, we'll hear about 10 new cert grants, and then they'll continue to take cases to the middle of January to be heard and decided this term. Anything they take after mid-January won't be heard till next October. So let me talk for a bit about what's on the docket, and then delighted to take any questions you have. I'm going to start alphabetically. I have to start with abortion rights. And the case is Dobbs versus Jackson Women's Health. It'll be argued on December 1st. It involves a Mississippi law that prohibits abortions after the 15th week of pregnancy. In Roe versus Wade in 1973, the Supreme Court said states cannot prohibit abortions prior to viability. In 1992, in Planned Parenthood versus Casey, the Supreme Court said it was reaffirming, quote, the essential holding of Roe versus Wade. The states can't prohibit abortions before viability. Viability is now thought to be about the 24th week of pregnancy. Mississippi obviously prohibits abortions before that. The issue granted cert by the Supreme Court is whether a state may prohibit abortions before viability. If a state can prohibit abortions after the 15th week of pregnancy, why not after the 6th week of pregnancy, which Texas, Ohio, Iowa have done? Why not prohibit abortions after the moment of conception, which is what Alabama has done? It's hard for me to count to 5 justices on the current court who could conceivably vote to strike down the Mississippi law. If you look at their opinions on the Supreme Court or on lower federal courts or their non-judicial writings, I cannot imagine Thomas, Alito, Gorsuch, Kavanaugh, Barrett voting to declare the Mississippi law unconstitutional. I think the question is, how far will they go in overruling Roe? It's possible they'll simply say they're allowing states to prohibit abortions after the 15th week of pregnancy and leave for future cases where the states can prohibit abortion after the 6th week of pregnancy or after the moment of conception. Or it's possible they'll use this case as the vehicle for expressly overruling Roe versus Wade that would allow each state to regulate abortion as it chooses. I think the court taking this case is an ominous sign with regard to abortion rights. There were a number of other states that had laws that prohibit abortions before viability. Lower courts always struck them down, and the Supreme Court always denied review. Here, the lower court struck this down, and yet the Supreme Court granted review. And 4 weeks ago, on September 1st, 5 justices, the 5 staunch conservatives, refused to issue an injunction of a Texas law that prohibits abortions after the 6th week of pregnancy, and it creates civil liability for those who aid or abet abortions. So this is going to be the most high-profile case of the term. Probably all discussion about the term. We shape it what the court does in Dobbs. Second area I want to talk about, again, going alphabetically by topic, concerns civil rights. And one of the cases that Alex suggested talking about, I think for good reason, is Thompson versus Clark. A little bit of background. In Heck versus Humphrey in 1994, the Supreme Court said that a person who's been convicted of a crime cannot bring a civil suit that would be inconsistent with conviction until the conviction is overturned. So if somebody is convicted, they can't sue the prosecutor for malicious prosecution until the conviction is overturned on direct appeal or in habeas, went some other way. Thompson versus Clark raises the question of what happens if there's been no conviction. Larry Thompson and his wife had a new 1-week-old baby. Larry Thompson's sister-in-law was staying with them. She's described as having some mental illness. She called 911 one night and said she thought the 1-week-old baby was being sexually abused. The baby's buttocks were red. EMTs came to their apartment, and Larry Thompson said, "I don't understand why you're here." They said it must be a wrong address. Later that night, the EMTs came back with several police officers. Larry Thompson said, "You're not coming into my apartment unless you got a warrant." The police put the door open, shoved Thompson to the floor. Thompson pushed back, and the police took the baby. The baby was examined at the hospital. The baby had a mild case of diaper rash. Thompson was charged with resisting arrest and obstructing a police officer. The prosecutor decides to dismiss the charges against Thompson. And all the prosecutor said was, "Court, we're dismissing the charges, quote, in the interest of justice." Thompson then sues the prosecutor for malicious prosecution. The district court dismisses Thompson's case. The district court says, "This sounds crazy, but the United States Court of Appeals for the Second Circuit has said that we can only hear a suit for malicious prosecution when there's, quote, an affirmative indication of actual innocence." Here, the charges were dismissed, but there was no declaration of actual innocence. Of course, we don't have a mechanism in our criminal justice system for someone whose charges been dismissed against them to get an affirmative indication of actual innocence. The case gets dismissed, the court doesn't have a trial to proclaim the person innocent. Does that mean that there can never be such suits? Does that mean that prosecutors have every incentive to bring and then dismiss charges, knowing that that will completely immunize them from being sued for malicious prosecution? That's why it's an important civil rights case. It was on Alex's list. Third topic for the term concerns criminal law. And the case that I want to talk about here is United States versus Tsarnaev, to be argued on October 13th. Dzhokhar Tsarnaev and his brother Tamerlan were responsible for planting the bombs in the pressure cookers at the Boston Marathon in 2013. 3 people died as a result. Hundreds more were injured. Tamerlan got killed by the police. Dzhokhar was arrested. He was prosecuted in federal court, charged with the murders. Dzhokhar's lawyers moved to change venue. They said, given all of the publicity in Boston surrounding the Boston Marathon bombing, there's no way you get a fair trial. The federal district court judge said, "I'm not going to change venue. There's enormous publicity about this all over the country. Instead, we'll be very careful in voir dire to be able to select a fair jury." During voir dire, the defense wanted the judge to ask the prospective jurors what they had heard or seen or thought about the case. The judge refused to ask those questions. Instead, the judge asked the prospective jurors, "Have you formed any conclusions about the case? And if so, can you still be open-minded?" The defense strongly objected that was asking the prospective jurors to judge themselves. The voir dire lasted 21 days. The defense 4 times moved for a change of venue, all denied. Tsarnaev was convicted and sentenced to death. The United States Court of Appeals for the First Circuit reversed the death sentence on 2 grounds. First, the judge didn't do an adequate job during voir dire to screen the jurors for possible prejudicial pretrial publicity. The First Circuit said, just asking the jurors, "Have you made up your mind, can be open-minded," isn't good enough. And also there was an issue at the sentencing phase, the penalty phase. Dzhokhar wanted to introduce evidence of another murder that his brother Tamerlan had committed. Dzhokhar's primary defense was that he was under the control and influence of his brother. The judge refused to allow the evidence of the other murder, So that would create a mini trial just about that. And the First Circuit found that to be a reversible error. It's interesting, the Biden administration has said that it's suspending the federal death penalty. And the issue here is whether or not the death penalty should continue to exist with regard to Tsarnaev. But it's clear that in this case, the federal government wants the Supreme Court to rule in its favor, even if there's not going to be the execution. The fourth case area that I want to talk about concerns gun rights, also on Alex's list. From 1791, when the Second Amendment was ratified, until June of 2008, not one federal, state, or local gun regulation was struck down by the Supreme Court. In the handful of Supreme Court cases about the Second Amendment, the court always said, it means what it says. It's a right to have guns for purpose of militia service. But in June 2008, in District of Columbia versus Heller, the Supreme Court declared unconstitutional a DC ordinance that prohibited ownership or possession of handguns. In an opinion by Justice Scalia, the Supreme Court said, the Second Amendment protects the right to have guns in the home for the sake of security. In 2010, in McDonald versus City of Chicago, the court said the Second Amendment applies to state and local governments. But that's it from the Supreme Court with regard to guns. There have been no Second Amendment decisions by the Supreme Court in the last 11 years since McDonald. None about the scope of the Second Amendment since Heller. Well, that's what makes New York Rifle and Pistol Association versus Bruin so important. It involves a New York state statute that restricts having concealed weapons. To have a concealed weapon outside the home, somebody needs to get a concealed weapons permit. And in order to get a concealed weapons permit, you need to show that your personal safety depends on it. Well, the issue in this case, which is going to be argued on November 3rd, is whether the Second Amendment protects the right to have guns outside the home. Does the Second Amendment protect the right to have concealed weapons? All five of the most conservative justices, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, in judicial opinions, whether on the Supreme Court or on courts of appeals, taken strong pro-gun rights positions. It'll be interesting to see what they do here in light of that. Most think they're likely to strike down the New York statute. The next topic, going alphabetically, is about religion. I think the place where we've seen the greatest change in the Supreme Court because of the shift in composition is with regard to the religion clause in the First Amendment. The current conservative majority no longer says or believes that there's a wall that separates church and state, the metaphor that Thomas Jefferson coined long ago. The conservative justices believe that the government violates the Establishment Clause of the First Amendment only if it coerces religious participation. And the conservative justices are very aggressive in protecting free exercise of religion, even when it means giving exemption from anti-discrimination or other general laws. Well, there's one important religion case on the docket so far this term. It's Carson versus Macon, to be argued on December 8th. Some background. For years, decades, the issue before the Supreme Court was, when may the government give aid to religious schools without it being an impermissible establishment of religion? And there were a lot of cases about things like, when can the government give sign language interpreters, or textbooks, or audiovisual equipment, or buses for field trips to parochial schools that wants to do so? Where does it violate the Establishment Clause? Now the issue is, when must the government give aid to religious schools, or it infringes free exercise of religion? The first case in this regard was 4 years ago, Trinity Lutheran versus Comer in 2017. The state of Missouri gave aid to public and secular private schools for surface of playgrounds. This was to provide a softer landing spot if a kid fell on the playground. Any public or secular private school that qualified could get this, but not a religious school. That's because of a provision of the Missouri Constitution that forbid direct or indirect state aid to religion. The Supreme Court 7-2 ruled against the state of Missouri. Chief Justice Roberts wrote for the court. Only Justices Sotomayor and Ginsburg dissented. Chief Justice Roberts said, whenever the government provides aid to secular private schools, it has to provide that to religious schools, unless the government can meet strict scrutiny, show that its action is necessary to achieve a compelling purpose. But then he limited the scope of the holding. In footnote 3, said, this is just about a case concerning aid to playgrounds and not about anything else. Justice Sotomayor wrote a vehement dissent joined by Justice Ginsburg. Justice Sotomayor said, this is the first time in history that the Supreme Court has ever required the government to give aid to religious institutions. The court followed Trinity Lutheran in June 2020 with Espinoza versus Montana Department of Revenue. Montana's legislature adopted a law that gave tax credits to people who gave money to private school tuition organizations. The Montana Supreme Court found this violated the Montana Constitution. Almost all the private schools in Montana are religiously affiliated. The Montana Constitution prohibits direct or indirect aid to religion. I would have thought this would have been the end of it. A state Supreme Court was finding a state law to violate the state constitution. But the Supreme Court 5-4 reversed the Montana Supreme Court. Once more, Chief Justice Roberts wrote for the court. He said, whenever the government gives aid to secular private schools, it must give that aid to religious schools, unless doing so would violate the Establishment Clause. And very little violates the Establishment Clause for the conservative justices. That leads to Carson versus Macon. In Carson versus Macon, it's going to be argued, as I said, on December 8th. What's involved in this case is there are parts of the state of Maine that are too rural to support public schools. So there are school administrative units, and they give money to the parents to send their children to private school. Under state law, the money can be used for any secular private school, but it can't be used for sectarian schools. Case involves two religious private schools and two parents that want to send children there, arguing that to deny them the state money violates free exercise of religion. So you can see how there's been a shift from what used to be the issue, when may the government give aid, to now it's when must the government give aid. And I think here, if the court continues in its pattern of the recent case, it will say that Maine is required to allow the money to be used in parochial schools. One more topic, and I'm glad to take questions, talk whatever you want, and that concerns the state secrets doctrine, another topic that Alex mentioned yesterday, and certainly one that relates most closely to the work of this group. In 1953, in United States versus Reynolds, the Supreme Court said that there is what's commonly referred to as the state secrets doctrine. This is a common law privilege that requires the exclusion of evidence or even the dismissal of cases when national security information might be disclosed. As an example, many years ago, I represented Valerie Plame and Joe Wilson in their suit against Dick Cheney, Karl Rove, Louis Libby, Richard Armitage, for Valerie Plame being exposed as a CIA agent and her career being ruined. And one of the grounds that the DC Circuit gave for dismissing the case was state secrets doctrine. Now, I already argued against it, saying everything has already come out and been public. There'd already been the Libby trial, but the DC Circuit said, among other things, state secrets doctrine. There aren't that many Supreme Court cases dealing with the state secrets doctrine. So it's particularly interesting that there are two state secrets doctrine cases on the docket for this term. The first is United States versus Zubaydah, Z-U-B-A-Y-D-A-H. It's going to be argued on October 6th, a week from tomorrow. Abu Zubaydah is a prisoner in Guantanamo, and he's been in Guantanamo since 2006. He said before he was taken to Guantanamo, he was taken to a black site in Poland where he was tortured. He says that he was waterboarded 83 times in 1 month. At one point, he was deprived of sleep for 11 consecutive days. There is a criminal investigation going on in Poland with regard to the torture. Zoraya files a lawsuit in the federal district court in Washington to obtain discovery from 2 CIA contractors who apparently information about this black site that was operating in Poland. So he's seeking information in federal district court so as to use as part of this criminal prosecution in Poland. It's an unusual procedural posture. The district court dismisses the case based on the state secrets doctrine. The United States Court of Appeals to the Ninth Circuit reverses. The Ninth Circuit says what the district court should do is see if it's possible to separate national security information from information that doesn't jeopardize national security. And only if it's impossible to separate the two should the whole case be dismissed based on the state secrets doctrine. The Supreme Court grants review. The issue is, was the remand to the district court to separate national security from non-national security information justified and appropriate? The other case with regard to the state secrets doctrine in a very different context is United States versus Zaga, which will be argued on November 8th. This involves Muslim men in Southern California who claim that they were impermissibly subjected to government surveillance, including the interception of the electronic communications, like their phone calls and their email. And the government moves to dismiss on the basis of the state secrets doctrine, and the district court agrees. The Ninth Circuit reverses in an opinion by Judge Marsha Brazan. The Ninth Circuit says the Foreign Intelligence Surveillance Act expressly authorizes money damages for those who are subjected to electronic surveillance in violation of that act. The Ninth Circuit says this is statutory authorization. The state secrets doctrine is a common law doctrine. Statutes override the common law. So where there is statutory right to sue is here, that then preempts a claim with regard to the state secrets doctrine. 12 Ninth Circuit judges dissented from the denial of en banc review, and there's clearly an ideological split in the Ninth Circuit, which may forecast what the Supreme Court's likely to do. I've covered just a handful of the major cases, but I think you can see why I say this is going to be, by any measure, a blockbuster year in the Supreme Court. Alex, I'm glad to take questions or do anything I can to be of help.
Thank you, Erwin. Always a fascinating review and very interesting. Maybe I can hog it a bit by asking you a question on the gun rights case, the Bruin case. My question is just more pragmatic, assuming that they strike, they go in favor of the Second Amendment and strike the New York State regulation. What's the practical impact of that? Can licensed gun carriers then take weapons to restaurants, on board a train, into any private setting? I've got a client, let's say, who wants to visit me in the law firm who's strapping a weapon. Can they carry guns in schools? Would there be any limitation, as you see it, as a practical matter, on the right to carry?
Obviously, so much will depend on how the court chooses to write the opinion. In District of Columbia versus Heller, Justice Scalia said, the Second Amendment right is not absolute. The government can restrict where people have guns, like in airports or in schools. And I can't imagine the Supreme Court would change that. The court said the government can regulate who has guns, like keeping those with a criminal conviction or a history of serious illness with guns. The court said the government can regulate the type of guns, prohibiting unusually dangerous weapons like bazookas from being possessed. I don't think this court's going to overrule any of that. Nor do I see the court saying that private property owners have to allow guns on their premises. You don't have to allow speech on your premises. You don't have to allow guns. So if in your law firm you want to say you can't carry a weapon, I think you'll be able to do that. But I think what the Supreme Court is likely to say is, that when you're outside the home, you have a general right to have a weapon for your sake of security, including a concealed weapon, and then it'll be subject to what regulations? And I think that the court will likely follow the same kind of regulations that Justice Scalia outlined in Heller.
So I'd like to ask you another question if I could, and then I'll really try to keep my mouth shut, Erwin, and that is on the Tsarnaev case, the Boston Marathon bombing case. First of all, I should note for the group that the ABA itself filed an amicus brief in that case. I haven't read the brief, but I don't think the ABA took a position one way or the other. But my question to you on Tsarnaev is, how do you think it should come out, and how do you think it will come out?
The former is much easier than the latter.
Mhm.
I think it should come out to affirm the First Circuit. I'm particularly interested in the first issue of how do you handle high-profile cases? I don't think it's sufficient in a case like this to say to the jurors, have you made up your mind? And even if you have, can you be objective about it? I think the First Circuit is right. That's asking people to judge themselves. I think what the defense was asking the judge to do was to probe what had the jurors seen, heard, read about the case. His way of trying to get the information of what were they thinking about the case. I think the second issue is a harder issue in the case because I understand the desire to avoid a trial within a trial. On the other hand, I would come out the way the First Circuit did. This is a death sentence. It seems to me you want to allow the defendant great latitude to be able to present whatever evidence he or she seems appropriate within a very broad definition of relevance when it's about a defense to a death sentence. I don't have a prediction of how the Supreme Court will come out. I'm most confident predicting where there's a track record of the justice on the issue. I can point to their track record on guns and their opinions. I can point to their track record on abortion. I don't know what they're going to do with this case.
Seeing no other questions, can I ask you one more then? And
I'm yours.
We've heard a lot recently in the news about what's called the shadow docket, which, as I understand, is the emergency docket that the Supreme Court uses in emergency TROs, injunctive type cases. And that was used, as I understand, in the Texas abortion statute recently. But could you tell the group briefly what the shadow docket is and whether, in your view, it's been used more and more in recent years by the Supreme Court?
The shadow docket, as you say, is when matters come to the Supreme Court for an emergency order. It'll be asking the justices to issue an injunction or to stay a lower court injunction. Law professors William Bowd at the University of Chicago, Stephen Vladeck at the University of Texas, have documented an increase in rulings by the court in the shadow docket. I'll give you an example from the last year. There have been at least 4 instances in which the justices were asked to issue injunctions against governors' closure orders imposed to stop the spread of COVID when there were religious challenges. In May of 2020, there was South Bay Pentecostal Church versus Newsom, where a church in California sought an injunction against part of Newsom's order, and it was 5-4 against the religion. The court denied the injunction. Roberts, Ginsburg, Brierson, and Kagan as the majority. In July of 2020, there's Calvary Chapel, Dayton Valley versus Sisolak, challenge against the governor of Nevada by a religious organization entity, and 5-4, the court denied the injunction, same 5 in the majority. Then the night before Thanksgiving, last November 25th, there was Catholic Archdiocese of Brooklyn versus Cuomo, where the court 5-4 on the shadow docket issued an injunction, the 5 in the majority, Thomas Alito, Gorsuch, Kavanaugh, and Barrett. And then there was Tandon versus Newsom in April of this year, where again, it was 5-4 to issue an injunction against the governor of California as part of the restriction that imposed to stop the spread of COVID, Thomas Alito, Gorsuch, Kavanaugh, and Barrett. So you see there the shift from the first 2 cases with Ginsburg to the latter 2 with Barrett. There had always been shadow docket cases in death penalty cases. So somebody is facing execution, going for a last minute stay to the Supreme Court. But we've seen much more and very inconsistent use by the Supreme Court with regard to the shadow docket. The Texas abortion case came up on the so-called shadow docket 3 weeks ago, but the justices refused to issue an injunction. By contrast, when Congress refused to fund the federal border wall, President Trump on his own diverted Defense Department money to do it. A district court issued a preliminary injunction against this, but the Supreme Court, as part of the shadow docket, lifted the preliminary injunction. Inevitably, matters are going to come to the court for emergency rulings. There's nothing objectionable about that. The shadow docket has a sinister connotation, shadow docket. And I don't think that's appropriate. My two criticisms of it are, first, the court seems very inconsistent, but when they will and won't grant injunctions or stays of injunctions. The other is, I think the court ignores the standard of review. All of you who handle appeals have to constantly deal with the standard of review. In many circuits, like the Ninth Circuit, in your brief, for each issue, you have to state the standard of review. Well, the standard of review for overturning an injunction or granting an injunction that was denied below is supposed to be an abuse of discretion standard of review. And yet the Supreme Court seems paying no attention at all to the standard of review.
Well,
There's a question from Tim.
go ahead, Tim, if you have a question, unmute yourself and go ahead, please.
Oh, thank you. If I could actually ask two quick questions. The first one is regarding the second, and I guess possibly both of the state secrets cases. Would, if the ruling comes in favor of the government, would that effectively bar not only all future torture claims, but Guantanamo torture claims, but any similar claims that anyone would want to bring, of CIA or misconduct on the part of that type of thing. And then the other question I had is, just in a general sense, which of the justices do you find to be the most useful in terms of the actual writing content in the writing of the opinions? Thanks.
Sure. Is the first question, obviously depending on how the court would write the opinion, but I think the answer would have to be yes. If they say that the state secrets doctrine keeps trial courts from separating classified versus unclassified information, if they say that the state secrets doctrine bars even when there's statutory claims, I don't see how a claim for torture could be brought. There have been circuit cases prior to this that have dismissed torture claims based on state secrets. There was a case in the Fourth Circuit involving Al-Masri versus the United States. If you've read the Jane Mayer book, The Dark Side, she talks about this instance in detail. Al-Masri was apprehended by mistake. He was confused with somebody else with the same name. He was taken to a black site. He was tortured. He had no information to reveal. So someone at Langley said, up the torture. And they did, and then realized finally that he had nothing to give. And they dumped him on the streets of Albania. He sued, and the United States Court of Appeals for the Fourth Circuit said, case had to be dismissed because of the state secrets doctrine. There's the Jefferson Data case out of the Ninth Circuit. There was a suit against a company who was allegedly flying planes that brought people to black sites. And the Ninth Circuit said state secrets doctrine dismissed. So if the court says state secrets, then I'm not sure how there could be suits with regard to torture. Second, in terms of the writing, if I could talk about the craft of writing apart from the content of the writing, I think Kagan is the best writer on the current court. I think that she is the clearest writer on the court. I think Sotomayor is a very impassioned writer. And I could point to, I think she sees herself as the conscience of the court. I was never a fan. I thought Justice Scalia was an excellent writer, but I so disliked the sarcasm of his writing. And I think Gorsuch has really picked up a lot of that sarcasm. But just in terms of the craft, I think the best writers who have ever served as justices were Louis Brandeis and Robert Jackson. But I think on the current court, I would say Kagan.
Thank you very much. I agree with you on Kagan.
Well, I don't know if there are other questions from the participants, but I think there might be, but I wanted to make sure. There is one question though, Erwin, that I'm getting, and that is, are there any interesting Section 1983 cases coming up in this term?
Stay tuned. There are a lot of cases that raise issues with regard to qualified immunity. The Supreme Court, year before last, in June of 2020, denied certain 10 cases that would have presented issues regarding qualified immunity. The Supreme Court last November, in a case called Taylor versus Riojas, R-I-O-J-A-S, found that there was not qualified immunity. It was a summary reversal of the Fifth Circuit. It was a case with truly horrific facts about the treatment of a prisoner. And the Fifth Circuit said, yes, it was cruel and unusual punishment, but there's no case on point that treating a prisoner this way violated the Constitution. And the Supreme Court 7-1 reversed the Fifth Circuit and made clear that it doesn't have to be a case on point so long as the officer's fair warning, fair notice. There's a lot of cert petitions pending. The one I'd especially look for is the Frazier case out of the 10th Circuit. It involves whether there's a right basically to photograph a police officer, and the police officer being sued for keeping someone from photographing the officer and what the officer is doing in public. And it raises issues with regard to qualified immunity. There's so many qualified immunity issues that might come to the court with regard to Section 1983. There's the effort to ask the court to reformulate the test for qualified immunity. There's cases that say that the court should go back to a required two-step approach, as it did in Saucier versus Katz and overruled in Pearson versus Callahan, having always first asked, is there a constitutional violation? And second, is there clearly established law that the reasonable officer should know? Be interesting to see if the court takes any of the qualified immunity cases. There's been so much criticism of qualified immunity from both the right and the left. On the right, the Cato Institute, law professor William Bowdy, I mentioned, criticized. Don Willett, a judge on the Fifth Circuit, who was a Trump appointee, very outspoken against the Fifth qualified immunity. But so have liberals been critical of qualified immunity, the ACLU. So be interested to see if that has any effect on the Supreme Court. There are no major cases that have been taken so far, but they still have half the docket to take. I say the Frazier case was, I think, on the long conference for yesterday.
Well, Dean Erwin, thank you so much for participating again. We really appreciate it. I personally very much appreciate hearing from you all the time, but you know, it's great, and very, very grateful to you. Thank you.
Thank you for having me, and thanks to all of you who came today. Always my great pleasure. Thank you. Take care. Thank you so much.